Basically, what is restraint of trade? Usually, in the context of business, the term restraint of trade refers to any activity or agreement that inhibits free competition in the market. While this concept is vital for maintaining fair competition, it can also significantly impact various aspects of your business operations. A restraint of trade clause is generally inserted into an employment agreement by the employer to stop an ex-employee from competing or using confidential information in order to protect their business interests and goodwill. There are different types of restraint of trade clauses, which include restraining the ex-employee from joining the competitor for a specific period of time and in a particular geographic area. Secondly, disclosing confidential information to the competitor, poaching or enticing any other employee to work for the competitor, and approaching or assisting your all clients for a period of time and in a particular geographic area after your employment relationship has ended. In Section 28 of Malaysian Contract Act 1950 generally state that agreements that restrain trade are void. However, there are three exceptions to this rule where certain agreements that restrain trade are considered valid. The first one is sale of goodwill. When a person sells the goodwill of a business, they may agree with the buyer to refrain from carrying on a similar business within specified local limit, provided those limits are reasonable. This is meant to protect the buyer interest in the business they have purchased. Secondly, partner on dissolution. Partner may agree that upon dissolution, some or all of them will not carry on a business similar to that of the partnership within specified local limits. This exception is intended to prevent unfair competitions among former partners. And lastly, the exception for restraint of trade is ongoing partnership. Partners may agree that while they are partners, they will not carry on any business other than that of the partnership. This is meant to ensure that partners are fully committed to the partnership business and not engaged in competing activities.
Okay, so the provisions regarding agreement in restraint of trade is Section 28 of the Contracts Act 1950, which says agreement in restraint of trade is void. Every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. This statutory provision basically provides that a restraint of trade clause cannot be enforced within the Malaysian jurisdiction. Okay, so now looking at the case of Vision Kas and Dina Kas Melaka, there is a matter relating to agreement to restraint of trade in this case. Okay, so the restrictive covenant in question sought to prevent the defendants from engaging in trade that was in competition with the plaintiffs for a specified period, which is 12 months after the termination of employment. And the restriction clause in this covenant is clause 2.1. Okay, so this is the clause 2.1, which is the restriction clause in this case, which is in question. Okay, so now the judgment of this case is that the court determined that the restrictive covenant did not meet the exceptions outlined in Section 28 of the Contracts Act 1950. As a result, the covenant was deemed void and unenforceable. The court found that the restraint imposed by the covenant was excessive and went beyond what was necessary to protect the legitimate interests of the plaintiffs. Therefore, the defendants were not legally bound by the restraint of trade agreement. The court then allowed the appeal by the defendants and dismissed the plaintiff's claim based on the covenant.
Good afternoon, I'm Nadra.
Good afternoon, Miss Nadra. I am Miss Tan.
Okay, so let's discuss the legal implications of the restraint of trade clause in your business agreement with Mr. Lim and the remedies available to you under the Contracts Act 1950.
Okay, I am actually concerned about the clause that restricts me from engaging in a similar business within the city for 5 years. So, what are the legal implications of this?
So, under Malaysian contract law, specifically the Contracts Act 1950, the restraint of trade clause are generally considered as void. Section 28 of the Contract Act is stipulate that the agreement restrains someone from engaging in a lawful profession, trade, or business are void. So the purpose of this provision is to protect individuals' freedom to work and do business without undue restrictions.
So, the clause in my agreement with Mr. Lim might be void.
Yes, correct. The clause that prevents you from engaging in a similar business within the same city for 5 years is a restraint of trade. Prima facie, this clause is void under Section 28 because it restricts your ability to compete and conduct business.
So, are there any circumstances where such a clause might be enforceable?
Yes, there are exceptions. A restraint of trade clause can be upheld if it is reasonable in terms of the interests of the parties involved and the public interest. The court considers several factors to determine reasonableness. It includes duration of the restriction, geographical scope, and the nature of the business. For example, for the duration of the restriction, a 5-year period is generally considered excessive and likely to be deemed unreasonable. And for the geographical scope, restricting trade within the entire city might be seen as too broad. Based on this factor, it's likely that a Malaysian court will find the clause in your agreement to be unreasonable and unenforceable.
I see. So, if I challenge this clause, what remedies can I seek under the Contracts Act 1950?
Okay, there are several remedies available to you, such as declaration the clause as void, restitution, and damages. You can seek a court declaration that the clause is void under Section 28. And if the court declares the clause is void, you may seek a restitution. And for damages, if you suffered quantifiable losses as a result of this restrictive clause, you may pursue a claim for damages.
I see. Thank you so much, Ms. Nagra, for explaining that to me.
You're welcome.
Good morning, Mr. Ahmad. I'm Akila, and I will be the one who will assist you today.
Hi, good morning. Thank you for your time. I have a few questions about my job contract. I recently started as a sales manager at electronics store. My employment contract has a non-complete clause that I didn't pay much attention before. So I worry that how it could affect my future employment. So can you explain about its enforceability?
I see. Could you provide me with the details of the non-compete clause?
Yes, the clause that I cannot work for any competing electronics store within a 10-kilometer radius from our store for the duration of my employment and after 2 years of my employment ends.
Okay, understood. Regarding your issues, I think we can start by discussing a few key aspects, and later on, I will provide you the next step that you can take into account. Firstly, we can look at the reasonableness of the restraint. 10-kilometer radius and a 2-year duration are quite specific. The court will likely consider whether these terms are reasonable and necessary to protect your employer's legitimate business interests without unduly restricting your ability to find new employment.
Alright, so what does the court usually consider when deciding if the non-compete clause is reasonable?
Usually, the court will look at several factors, including the geographic scope, the durations, and the scope of the restriction itself. They will assess whether the clause is narrowly tailored to protect your employer's interests, such as trade secrets, customer relationships, or other proprietary information. They will also consider whether it unduly limits your ability to earn a livelihood.
Alright, so my question is, in my case, do you think the geographic scope and the duration are reasonable?
It depends on several factors, including the nature of the market and the business. Generally, courts are cautious about clauses that span long durations and wide areas. 2 years is relatively long for a non-compete, and a 10-kilometer radius could be seen excessive depending on the local market density. We will need to demonstrate that these restrictions are overly broad and not necessarily to protect your employee interests. Secondly, not only the geographic scope and duration, we can also look at the legitimate business interests. The courts will balance the protection of this business interest against your right to work and earn a livelihood. If the clause is restrictive and unfairly limits your ability to find employment, it may not be upheld. The court will consider whether less restrictive means could have been used to protect the business interest without imposing undue hardship to user.
Okay, alright. But what if the clause is deemed unreasonable? What happens next?
If the court finds the non-compete clause unreasonable, it could declare it void or modify it to make it reasonable. For example, the court might reduce the duration to 6 months or limit the geographic scope. There is also the possibility of the clause being struck out entirely if it's deemed too restrictive.
Alright, will there any legal grounds that could make this clause void from the beginning?
Yes, under Section 28 of the Contract Act 1950, agreement in restraint of trade are generally void unless they fall within certain exceptions. The Act permits restraint if they are reasonable in the interests of the contracting parties and the public. If we can argue that the clause imposed undue restrictions on you and it is not necessary to protect legitimate business interests, we might be able to have it declared void.
Alright, that's good to know. But the next step that I will take?
First, we should review your employment contract in detail to understand the full context. Then, we can gather evidence to support your case, such as details about your role, the market, and how the non-compete clause affects your employment opportunities. We might also consider negotiating with your employer to modify the clause or seeking a declaratory judgment from the court, and you may seek for damages and compensation if the non-compete clause has already caused you to suffer damage. This will depend on the specific circumstances and whether the clause is found to be unenforceable.
Thank you. This is very helpful. I will gather all the information and the detail that you need.
Great. Once we have all the information, we can develop a strategy to address this issue effectively. Feel free to contact me if you have any more questions in the meantime.
Yeah, too. Thank you for the advice.
You are welcome. For the recommendations on this matter, you will be assisted by our colleague.
All right.
Hi, I am Muslimat. Hi, I'm Saidatu. Please have a seat. Okay, actually I am being asked to go to you after I met Miss Nazla to ask you what should be my next step regarding my contract between me and Miss Lim. So I just want to ask you, can you propose any recommendations or any disruptions regarding this matter? Okay, about this, from what I have been informed by my colleague about your situations, I believe that you have two options here. The first one is if you wish to go to the court and bring this matter forward, then we can do that. But if you do not wish to do so, then we can proceed with ADR or alternative dispute resolution. So the ADR type that I think fit best for your situation is arbitration. So what is arbitration? It means that arbitration is when both parties, or in your situation like Mr. Lim and you, decided to appoint an arbitrator as the neutral party to be fair to both of your arguments, and then he will come up with a binding decisions that will bind both of you, just like the judgment from the court. I see. Can you give me an examples of the arguments and how the flow of the arbitration process? Okay, about that, one of the arguments that you can go with is that you can claim that the contract that you have entered to with Mr. Lim contains ROT or restraint of trade. So according to the Section 28 of Contract Act 1950, all contract that contains ROT will become void. When a contract is void, it will be treated as if it never happened in the first place. Thus, we can say that whenever the contract is void, the contracting parties are considered as if they never entered into the contract in the first place. Both parties are back to square one as in their original position before they even decided to enter into the contract. Another argument that you can go with, if you decide to proceed with the contract, then you may say that the contract holding is valid, but the only void thing is the clause itself. So you may ask from the arbitration to set aside the clause from the contract so that you can proceed with the contract. As for the flow of the arbitration, after you are done with your arguments, Mr. Lim will also be given some time to explain his arguments and evidences before the arbitrator. And then, after both of you are done with your arguments, the arbitrator will give a decision after he has listened to all the arguments and evidences provided and presented before him. Some of the possible outcome that the arbitrator may come up with if he, let's say, he decided to go or he agrees with your arguments, he can say that yes, the contract is void. So you are back to square one, like you have never even entered in the first place. Or he can say that yes, you can exclude the clause from the contract and you can still proceed with the contract. Is that clear to you?
That is such a very clear explanation to me. Thank you so much for explaining to me.
Have a good. I have a good day. Thank you.
Hi, I'm Mr. Ahmad. I'm here today to get your recommendation about my situation. Is there any way that we can do to solve my problems?
Hi, Mr. Ahmad. I'm Miss Sophia, so I'm here to assist you. So from your situation that I heard from my colleagues, the best solution or recommendation strategies that you can use for your disputes is that use the alternative dispute resolution ADR, which is mediation. Mediation is typically a voluntary process that provides an open forum to the parties involved to settle their disputes without going to the court, but with assistance of a mediator, which have to be in the stand of neutrality. So, for your information, in Malaysia, there are several institutions governing the mediation process to provide assistance for fair settlement between parties, like Malaysian Mediation Centre (MMC). So, both of you can seek MMC guidance to solve your disputes. So, according to your situation, the mediator may suggest to both of you to exclude the clause from the agreement, while the other clauses are still valid as per Section 28 of the Malaysian Court Act 1950. So, in your agreement, I see that it states that Mr. Ahmad can work for any competing electronic stores within a 10-kilometer radius of the business premises for the duration of your employment and for a period of 2 years after its termination. Is that right?
Yes, it is.
As you can see here, this kind of condition is considered void because there is restraint of trade made against you, Mr. Ahmad, by Mrs. Tan. Mrs. Tan can put this kind of conditions during your employment only, not after your termination of contract. So, the mediator may suggest excluding this clause that contain ROT. This method is advantageous to the both of you since it's time and cost effective. However, you, Mr. Ahmad, and Mrs. Tan may choose whether you both want to agree to it or not. If both of you agree to the suggestion made by the mediator, the case will be solved. And if not, both of you can bring this case to the next step, which is to the court to seek for an injunction.
I see.
So, what does it mean by injunction? Injunction is an order of the court for a party to do or not to do something. In the case of you, Mr. Ahmad and Mrs. Tan, the court may order the same, which is to exclude the clause of the agreement that contains ROT only, while other clauses of the agreement are still enforceable. It is because the contract is valid, but the clause that contains ROT was void. So, in conclusion, in both solutions, it may sided to you, Mr. Ahmad. So, it's up to you to decide to choose which one do you want to use. That's it.
But Mr. Ahmad, if you wish to continue with this agreement, both you and Ms. Tan may come up with new agreement, or you can modify the condition or modify the clause before you enter into the contract.
Alright, thank you for your both advice.
It's okay. Have a good day.
Have a good day.
Assalamualaikum warahmatullahi wabarakatuh. I will present the conclusion. Okay, first, in Malaysia, the legal landscape surrounding the non-compete clause is to specific regulation. This clause, unless carefully crafted to align with permissible exception, are generally considered void and unenforceable. This means that former employees are afforded significant freedom to pursue their professional endeavors without undue restriction. Okay, for instance, however, individual who have previously worked for a company are not prohibited from engaging into similar business activity, joining competing firm, or even establishing their own venture in the same industry. This freedom foster a competitive environment and encourage innovation and entrepreneurship. But however, it is essential to highlight that this liberty comes with responsibility. While former employees are permitted to venture into similar field, they must adhere to ethical standard and refrain from exploiting confidential information acquired during their employment for personal advantage or to the detriment of their former employees. Furthermore, employers should ensure that their employment agreement are drafted in compliance with Malaysian law and regulation. Failure to do so could result in void clauses and render the agreement unenforceable, potentially leaving the employers vulnerable to legal dispute. In essence, striking a balance between the right of employees and between the right of employers and the freedom of employees is crucial in crafting enforceable and equitable employment agreement in Malaysia. In In essence, striking a balance between the right of employers and the freedom of employees is crucial in crafting enforceable and equitable employment agreement in Malaysia. By understanding and adhering to the legal provision governing non-compete clause, both parties can navigate the employment landscape with clarity and confidence. Thank you.